Today I am going to start the procedure for amendment. This is chapter 10. The nature of the amending process envisaged by the makers of our constitution can be best explained by referring to the observation of Pandit Nehru, quoted under reconciliation of a written constitution with parliamentary sovereignty, NT, that the constitution should not be so rigid that it cannot be adapted to the changing needs of national development and strength. There was also a political significance in adopting a facile procedure for amendment, namely that any popular demand for changing the political system should be capable of realization if it assumed a considerable volume. In the words of Dr. Ambedkar explaining the proposals for amendment introduced by him in the Constituent Assembly, those who are dissatisfied with the Constitution have only to obtain in two-thirds majority, and if they cannot obtain even a two-thirds majority in the parliament elected an adult franchise in their favor, their dissatisfaction with the constitution cannot be deemed to be shared by the general public. Elements of flexibility were therefore imported into a federal constitution which is inherently rigid in its nature. According to the traditional theory of federalism, either the process of amendment of constitution is entrusted to a body other than the ordinary legislature, or a special procedure is prescribed for such amendment in order to ensure that the federal compact may not be disturbed at the will of one of the parties of the federation, viz. The federal legislature. But as has been explained at the outset, the framers of our constitution were also inspired by the need for the sovereignty of parliament elected by universal suffrage to enable it to achieve a dynamic national progress. They therefore prescribed an easier mode for changing those provisions of the constitution which did not primarily affect the federal system. This was done in two ways: by providing that the alteration of certain provisions of the constitution were not to be deemed to be amendment of the constitution. The result is that such provisions can be altered by the union parliament in the ordinary process of legislation, that is, by a simple majority. Other provisions of constitution can be changed only by the process of amendment which is prescribed in Article 368, but a differentiation has been again made in the procedure for amendment according to the nature of the provisions sought to be amended. While in all cases of amendments of the constitution a bill has to be passed by the union parliament by a special majority, in the case of certain provisions which affect the federal structure a further step is required, viz. A ratification by the legislature of at least half of the states before the bill is presented to the president for his assent, Article 368. But even in these later groups of cases, the law which eventually affects the amendment is a law made by parliament, which is the ordinary legislative organ of the union. There is thus no separate constituent body provided by our constitution for amending process. The procedure for amendment is: an amendment of the constitution may be initiated only by the introduction of a bill for the purpose in either house of parliament, and when the bill is passed in each house by a majority that is more than 50% of the total membership of that house, and by a majority of not less than two-thirds of the members of that house present and voting, it shall be presented to the president for his assent, and upon such assent being given to the bill, the constitution shall stand amended in accordance with the terms of the bill. If however such amendment seeks to make any change in the following provisions, namely the manner of election of the president, Article 54 and 55 extend the executive power of the union and the state, Article 73, 162, the Supreme Court and the High Courts, Article 241, Chapter 4 of Part 5, Chapter 5 of Part 6, Distribution of Legislative Power between the Union and the State, Chapter 1 of Part 11, any of the list in the 7th Schedule, Representation of the States in Parliament, Article 80 to 81, 4th Schedule, Provisions of Article 368 itself. The amendment shall also require to be ratified by the legislatures of not less than one half of the states by resolution to the effect passed by those legislature before the bill making provision for such amendment is presented to the President for assent. Article 368(2). It is clear from the above that the amending process prescribed by our Constitution has certain distinctive features as compared with the corresponding provisions in the leading constitutions of the world. The procedure for amendment must be classed as rigid insofar as it requires a special majority and in some cases a special procedure for amendment as compared with the procedure prescribed for ordinary legislation. But the procedure is not as complicated or difficult as in the USA or in any other rigid constitution. Subject to the special procedure laid down in Article 368, our Constitution vests constituent power upon the ordinary legislature of the Union, that is the Parliament, of course acting by a special majority. And there is no separate body for amending the Constitution as exists in some other constitution, as for example Constitutional Convention. The state legislature cannot initiate any bill or proposal for amendment of the Constitution. The only mode of initiating a proposal for amendment is to introduce a bill in either house of the Union Parliament. Subject to the provision of Article 368, Constitution amendment bills are to be passed by the Parliament in the same way as ordinary bills. In other words, they may be initiated in either house and may be amended like other bills, subject to the majority required by Article 368, but for the special majority prescribed, they must be passed by both the houses like any other bill. It would be pointed out in this context that there is another important point on which the passage of the Constitution amendment bill differs from the procedure relating to the passage of a bill for ordinary legislation. Article 108 provides that if there is a disagreement between the two houses of Parliament regarding the passage of bill, the deadlock may be solved by the joint session of the two houses. But it is clear from the Article 108(1) that the procedure for joint session is applicable only to bills for ordinary legislation which come under Chapter 2 of Part 5 of the Constitution, and not to bills for amendment of the Constitution, which are governed by the self-contained procedure contained in Article 368(2). The requirement of the special majority in both houses in Article 368(2) would have been nugatory had the provision as to joint session been available in this sphere. The previous sanction of the President is not required for introducing in Parliament any bill for amendment of the Constitution. The requirement relating to ratification by the state legislatures is more liberal than the corresponding provisions in the American Constitution. While the latter requires ratification by not less than 3/4 of the states, under our Constitution ratification by not less than half of them suffices. In the case of ordinary bill governed by Article 111, when the bill, after being passed by both houses of Parliament, is represented to the assent therefrom, in the latter case, the bill cannot become an act. But the amendment of Article 368 in 1971 has made it obligatory for the President to give his assent to a bill for amendment of the Constitution when it is presented to him after its passage by the legislature. In short, though the formality of President's assent has been retained in the case of an amendment of the Constitution in order to signify the date when the amendment will become operative as part of the Constitution, the President's power to veto a bill for amendment of the Constitution has been taken away. By substituting the words shall give his assent in clause 2 of Article 368 as it stands after the Constitution 24th Amendment Act 1971. There has been a historical controversy as to whether an amendment of the Constitution made in the manner provided for under Article 368 must have to conform to the requirements of Article 13(2) as a law as defined in clause 3 of Article 13, or in other words, whether a Constitution Amendment Act would be void if it seeks to take away or is consistent with a fundamental right enumerated in Part 3 of the Constitution. Until the case of Golaknath, the Supreme Court has been holding that no part of our Constitution was unamendable, and the Parliament might, by passing a Constitution Amendment Act in compliance with the requirements of Article 368, amend any provision of the Constitution, including the fundamental rights and Article 368 itself. It was held that law in Article 13(2) referred to ordinary legislation made by Parliament as a legislative body and would not include an amendment of the Constitution which was passed by the Parliament in its constituent capacity. But in Golaknath's case, a majority of 6 judges in a special bench of 11 overruled the previous decisions and took the view that though there is no express exception from the ambit of Article 368, the fundamental rights included in Part 3 of the Constitution cannot by their very nature be subject to the process of amendment provided for in Article 368, and that if any such rights is to be amended, a new Constituent Assembly must be convened for making a new Constitution or radically changing it. The majority in Golaknath's case rested its conclusion on the view that power to amend the Constitution was also a legislative power conferred by Article 245 by the Constitution, so that a Constitution Amendment Act was also a law within the purview of Article 13(2). After the Golaknath's decision, Parliament sought to supersede it by amending Article 368 itself by the Constitution 24th Amendment Act 1971, as a result of which an amendment of Constitution passed in accordance with Article 368 will not be law within the meaning of Article 13, and the validity of Constitution Amendment Act shall not be open to question on the ground that it takes away the effects or fundamental right Article 368(3). Even after this specific amendment of the Constitution, the controversy before the Supreme Court did not cease, because the validity of the 24th Constitution Amendment Act itself was challenged in a case from Kerala, Kesvanand versus State of Kerala, which was heard by full bench of 13 judges. The majority of full court upheld the validity of the 24th Amendment and overruled the case of Golaknath. The question that thus been settled in favor of the view that a Constitution Amendment Act passed by Parliament is not law within the meaning of Article 13, the majority in Kesvanand's case upheld the validity of Clause 4 of Article 14 and in a corresponding provision in Article 368(3), which has been inserted by the Constitution 24th Amendment Act 1971, and reads as follows: nothing in this article, that is Article 13, shall apply to any amendment made under Article 368. In the result, fundamental rights in India can be amended by an act passed under Article 368, and the validity of a Constitution Amending Act cannot be questioned on the ground that the act invades or encroaches upon the fundamental rights. Another question which has been mooted since the case of Golaknath is whether outside Part 3 fundamental rights there is any other provision of the Constitution Constitution of India, which is immune from the process of amendment in Article 368, though the majority in Keshavanand's case has overturned the majority view in Golaknath that fundamental rights cannot be amended under Article 368, it has affirmed another proposition asserted by the majority in Golaknath's case, namely that there are certain basic features of the Constitution of India which cannot be altered in exercise of the power to amend it under Article 368. If therefore a Constitution Amendment Act seeks to alter the basic structure or framework of the Constitution, the court would be entitled to annul it on the ground of ultra vires, because the word amend in Article 368 means only changes other than altering the very structure of the Constitution, which would be tantamount to meaning making a new Constitution. These basic features, without being exhaustive, are sovereignty and territorial integrity of India, the federal system, judicial review, parliamentary system of government. Applying this doctrine that judicial review is a basic feature of the Constitution of India, the majority in Keshavanand's held the second part of Section 3 of Constitution 25th Amendment Act 1971 relating to Article 31 as invalid. The portion so invalidated read, and no law containing a declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy. Article 31C, which was introduced by Section 3 of the 25th Amendment Act, provided that if any law seeks to implement the directive principle contained in Article 39BC, that is regarding socialistic control and distribution of the material resources of the country, such law shall not be void on the ground of contravention of Article 14 or 19. B. It further provided that if anybody challenges the constitutionality of any such law, the court would be precluded from entering into the preliminary question, namely whether such law is in fact a law giving effect to Article 39B or C, if on the face of the Act there was a declaration of the legislature that it is for giving effect to such directive policy. In other words, by adding a declaration to an Act, the legislature was empowered by the 25th Constitution Amendment Act to deprive the court of their power to determine the validity of the act on the ground that it is contravened some provisions of the Constitution. The majority held that Article 368 did not confer any such power to take away any judicial review in the name of amending the Constitution. The foregoing view of the majority in Keshavanand's case as to basic features are debatable inasmuch as there is no express limitation upon the amending power conferred by Article 368(1). If it is supposed that there are some implied limitations, it is difficult to appreciate how the court, after holding that the fundamental rights did not constitute such inviolable part of the Constitution, would come to the conclusion that judicial review, which is an adjunct of fundamental rights, could be so considered. It would therefore be no wonder if another full bench of Supreme Court comes to overturn this view of Keshavanand's case on the grounds that Article 368(1) as it stands amended in 1970 and 71 makes it clear that not only the procedure but also the power to amend the Constitution is conferred by Article 368 itself and cannot be derived from somewhere else, such as Article 224.5. Hence, Article 245. Hence, the limitation, if any, upon the amending power must be found from Article 368 itself. and not from any theory of implied limitation. That the word repeal in Article 368(1) also makes it clear that amendment under Article 368 includes a repeal of any of its provision, including any supposed basic or essential provision. That the Constitution of India makes no distinction between amendment and total revision, and as do some other constitutions such as Swiss. Hence, there is no bar to change the whole constitution in exercise of the amending power, who is described as the constituent power, Article 368(1), and that accordingly it would not be necessary to convene a constituent assembly to revise the constitution in toto. The Indira government sought to arrest these implications of Keshavananda's and cut the fetters sought to be imposed on the sovereignty of Parliament as a constituent body by inserting two clauses 4 to 5 in Article 368. By the 42nd Amendment Act 1976, Clause 5 declares that there shall be no limitation on the constituent power of Parliament to amend the provisions of this Constitution, and that at any rate the validity of no Constitution Amendment Act shall be called in question in any court on any ground. The foregoing attempt to preclude judicial review of Constitution amending acts has, however, been nullified by the Supreme Court by striking down Clause 4(5) as inserted in Article 368 by the 42nd Amendment Act by its decision in the Minerva Mills case, on the ground that judicial review as a basic feature of the Indian constitutional system, which cannot be taken away even by amending the Constitution. So far, the decision in Keshavananda has been followed in subsequent cases by the Supreme Court. As a result, Article 368 as to interpreted by the highest court would lead to the following propositions. Any part of the Constitution may be amended after complying with the procedure laid down in Article 368. No referendum or reference to Constituent Assembly would be required to amend any provision of the Constitution, but no provision of the Constitution or any part thereof can be amended if it takes away or destroys any of the basic features of the Constitution. Thus, apart from the procedural limitation expressly laid down in Article 368, substantive limitation founded by the doctrine of basic features has been introduced into our Constitution by judicial innovation. The Supreme Court has refused to foreclose its list of basic structure features from the various decisions. So far, the following list may be drawn up: supremacy of the Constitution, rule of law, the principle of separation of powers, the objectives specified in the preamble to the Constitution, judicial review, Article 32 and 226, federalism, secularism, the sovereign democratic republican structure, freedom and dignity of the individual, unity and integrity of the nation, the principle of equality, not every features of equality, but the quintessence of equal justice, the essence of the other fundamental rights in Part 3, the concept of social and economic justice to build a welfare state, Part 4 in toto, the balance between fundamental rights and directive principles, the parliamentary system of government, the principle of free and fair elections, limitations upon amending power conferred by Article 368, independence of judiciary, effective access to justice, power of the Supreme Court under Article 32, 136, 141, and 142, legislation seeking to nullify the awards made in exercise of the judicial power of the state by arbitration tribunal constituted under an act since its commencement on January 26, 1950. Constitution of India has been amended 83 times till December 2000 by passing acts of parliament in the manner prescribed by Article 368. See Table 4 post. Since all these amendments acts have been mentioned with full particulars in Table 4 post, it is needless to reproduce them in the present chapter. Nevertheless, the 42nd and 43rd and the 44th Amendment must be given a fuller treatment in view of its serious repercussions in the political as well as the legal world. All previous amendments paled into insignificance after the passing of the 42nd Amendment Act 1976, which alone would illustrate how momentous is the amending power under the Indian Constitution and how easy it is to change extensive and vital provisions of Constitution without any elaborate formalities when the ruling party has a comfortable majority in the two houses of Parliament. The 42nd Amendment Act was practically a revision of the Constitution for following reasons. In extent, it introduced changes in the preamble, as many as 53 articles, as well as the 7th schedule. As to substantive changes, it sought to change the vital principle underlying the 1949 Constitution. Judicial review of ordinary laws. It made for the first time a distinction between union and state laws for the purpose of challenging their constitutionality on the ground of contravention of any provision of the Constitution, and provided broadly that a high court could not pronounce invalid any central law, including subordinate legislation under such law, on the ground of unconstitutionality, that the Supreme Court could not in its jurisdiction under Article 32 pronounce a state law as unconstitutional unless the central law had also been challenged in such proceeding. If any law was made to implement any of the directives included in Part 4, Article 31C, or in exercise of the new power under Article 31D to ban antisocial activities or associations, the validity of such law could not be challenged on the ground of contravention of Article 14, 1931. Above all, an artificial majority of judges was required both in the Supreme Court and High Court in order to pronounce a law to be unconstitutional and invalid. Judicial review of Constitution Amendment Act. By amending Article 368, it was provided that a law which is described as a Constitution Amendment Act would be completely immune from challenge in a court of law, whether on a procedural or substantive ground. Thus, even if such a bill had not been passed in conformity with the procedure laid down in Article 368 itself, nobody would be entitled to challenge it in any court on that ground, a position which is juristically absurd. Fundamental duties. For the first time, a chapter on fundamental duties, Article 51A, was introduced in order to counteract the sweep of fundamental rights. Even though no sanction has been appended to these duties, it is obvious that if a court takes these duties into consideration along with fundamental rights, the scope of the free play of the rights would to that extent be narrowed down. Fundamental rights devalued. By expanding the scope of Article 31C, it was provided that if any law seeks to implement any of the directive principles included in Part 4, such law would be altogether immune from the judicial review on the ground of contravention of fundamental rights. This is exactly the reverse of what was provided in the 1949 Constitution. The load on fundamental rights, in short, became ruthlessly heavy after the cumulative burden of Article 31A, 31B, 31C, 31D, and 51A. When the Janata Party came to power towards the end of March 1977, they sought to take early steps to fulfill their election pledge to undo the extensive mischief which had been done to the Constitution by the 42nd Amendment Act as outlined above. But owing to the fact that Janata had no majority, not to speak of two-thirds majority in Rajya Sabha, which was required to pass a constitution amending bill under Article 368. Their attempts in this behalf were checkered and not only partially successful. The first step was abortive, namely that the 43rd Amendment Bill, which was introduced in the Lok Sabha in April 1977, had to be left over till the next session, hoping to gain some more seats in Rajya Sabha at the periodical election to be held held to that house in the meantime. Eventually, the 43rd Amendment Act 1977 was passed with the aid of the votes of Congress. The attitude of that party, however, changed when the next bill, which the 45th, was taken to the Rajya Sabha in 1978, as a result of which this bill was enacted only in a truncated shape as the 44th Amendment Act 1978. The changes made by the 43rd and the 44th Amendment Act were summarized in Table 4 post. Briefly speaking, the changes made by the 43rd and 44th Amendment Acts are summarized in Table 4. Briefly speaking, the 43rd Amendment Act 1977 simply repealed those provisions which had been added by the 42nd Amendment Act to curb judicial review. Article 31D, 32A, 144A, 226A, 228A. The changes made by the 44th Amendment are more extensive. It is not only omitted some more of the articles which had been inserted by the 42nd, as for example Article 257A, 329A, but also made amendments in other articles in order to restore those provisions to their ante-1976 text, as for example Article 226. Apart from combating the mischiefs introduced by the 42nd Amendment, the 44th Amendment Act introduced additional changes, as for example by omitting the fundamental rights to property in Article 19(1)(f) and Article 31(2). Since Janata failed to secure the passage of a number of clauses of the 45th Amending Bill, the stamp of the 42nd Amendment on various provisions such as Article 368 still remains. Besides, the Janata government have themselves retained some of the provisions as amended by the 42nd Amendment which they considered too beneficial, as for example Article 74(1), Article 311 of our subsequent amendments. The 73rd and 74th Amendment Act of 1992 deserves special mention inasmuch as it has introduced the electoral system for the composition of the units of local government below the states, viz. the panchayats in the rural areas and the municipalities in the urban areas. It is evident that instead of being rigid, as some critics supposed during the early days of the Constitution, the procedure for amendment has rather proved to be too flexible in view of the ease with which as many as 83 amendments have been made during the 50 years of the working of the Constitution. So long as the party in power at the center has a solid majority in Parliament and in more than half of the state legislatures, the apprehension of impartial observers should be not so as to the difficulty of the amendment, but as to the possibility of its being used too often either to achieve political purposes or to get rid of judicial decisions which may appear to be unwholesome to the party in power. Judges may of course err, but as has already been demonstrated, even the highest tribunal is likely to change its views in the light of further experience. In the absence of serious repercussions or emergent circumstances or a special contingency, as for example to admit Sikkim by the 35th and 36th Amendments, therefore the process of constitutional amendments should not be resorted to for the purpose of overriding unwelcome judicial verdicts so often as would generate in the minds of the lay public an irreverence for the judiciary, thus shaking the very foundation of the constitutional government.